Hello everyone, welcome to SJ LearnX YouTube channel. In this video, we will discuss about the meaning of burden of proof. The concept of burden of proof is one of the most fundamental important principle in the law of evidence. Section 101 of the Indian Evidence Act clearly states that whoever desires a court to give judgment in his favor must prove that the existence of facts which he asserts. In simple language, this means if you are making a claim before the court, you are responsible for proving the claim with the evidence. Courts do not assume facts automatically just because someone says something. Evidence must be support the assertion. Now understand the logic behind this rule. If courts allowed people to win cases without proof, the entire justice system would collapse. Therefore, law places responsibility on the person who approaches the court and asks for some relief. This principle applies both in civil cases and in criminal cases. Although the degree of proof differs, the basic idea remains the same. The person who alleges must prove. Let us take a simple example. Suppose a person A files a civil suit claiming that person B borrowed 1 lakh from him and has not returned the money. Now A is asking the court to pass judgment in his favor and order B to pay the amount. Therefore, the burden lies on A to prove three things here. First one, that money was actually lent. Second one, that B was under an obligation to repay. And third one, that repayment has not been made. If A fails to prove these facts with evidence, the court will dismiss his claim. So the most important takeaway from the section 101 is that burden of proof lies on the party who asserts a fact, not on the party who denies it. The defendant does not need to prove innocence unless the plaintiff or prosecution first establishes the claim. This principle forms the foundation of the entire law of evidence, and many other sections are built upon this rule. Now let us see legal burden versus evidential burden. In this slide, we are going to understand a very important distinction within the concept of burden of proof. That is the difference between legal burden and evidential burden. Many of us get confused between these two, but for the distinction between these two is important. Although both relate to proving facts, their nature and function are different. First, let us understand legal burden, which also called persuasive burden. This is the permanent responsibility placed on a party to prove its case to the required standard. In civil cases, this burden generally lies on the plaintiff, and in the criminal case, it lies on the prosecution. The important point to remember is that the legal burden does not shift during the trial. Even if the opposite party produces some evidence, the original party still carries the ultimate responsibility to convince the court. For example, in criminal case, no matter what defense the accuser takes, the prosecution always retain the legal burden to prove guilt beyond a reasonable doubt. Now let us understand the evidential burden. Evidential burden is a temporary obligation to produce evidence on a particular issue at a particular stage of the trial. Unlike legal burden, this burden can shift from one party to the another depending on the circumstances. One party produces sufficient evidence to create a presumption or probability. The other party may need to respond with counter evidence. So evidential burden keeps moving during the trial process. For example, suppose prosecution proves that the accused was present at the crime scene with a weapon. At this stage, the evidential burden may shift to the accused to explain why he was present there. If the accused gives a reasonable explanation, the burden may again shift back to prosecution. However, remember one golden rule here. Even though even evidential burden shifts. The legal burden in criminal cases always remains on the prosecution. This distinction helps courts maintain fairness while ensuring proper proof of facts. Now we move on to section 102, which explains how courts determine on whom the burden of proof lies at the beginning of the case. The section 102 provides a very practical test. It says that the burden lies on the party who would fail if no evidence at all were given by either side. This is commonly known as the test of no evidence rule. So, the judge imagines a situation where neither party produces any evidence and then asks who would lose. The party carries the burden of proof. Let us understand this with a civil example. Suppose A files a suit against B claiming that B owes him 2 lakh under a loan agreement. Now imagine that neither A nor B produces any evidence in the court. In such situation, A would lose the case because he is the one asserting that money is due. Therefore, under section 102, the burden lies on the A. This helps courts identify the starting point of proof in litigation. Now let us consider example in criminal law. If the prosecution produces no evidence against the accused must be acquitted because guilt has not been proven. Therefore, the burden lies on the prosecution. This principle is closely connected with the presumption of innocence in criminal law. The accused is presumed innocent until proven guilty, so the prosecution must first establish the case. So, the key takeaway from section 102 is that the burden of proof depends on the nature of the claim and who would fail in the absence of evidence. This section works together with section 101 to determine the initial responsibility of the proof. Now we come to section 103, which deals with a significant, a slightly different situation compared to the section 101 and 102. While earlier sections talk about the burden of proving the main case, the section 103 focus on the burden of proving a particular or specific fact. This section states that the burden is proving any particular fact lies on the person who wishes the court to believe in its existence. In simple words, whenever a party introduces a special fact into the case, that party must prove it. This provision becomes important when a party takes a special defense or makes an additional assertion beyond the basic claim. Even if the main burden lies on one party, the burden of proving certain specific facts may lie on the other party. Therefore, Section 103 operates independently for particular issues within a case. It ensures fairness because the person who has special knowledge of a fact should be responsible for proving it. Let us take a criminal example. Suppose the prosecution accused A of committing murder at 8 p.m. in Delhi. Now, a claim that at that time he was in Mumbai attending a wedding. This defense is called alibi. Since the accused is asserting this special fact, the burden to prove the alibi lies on him under section 103. The prosecution does not need to prove that A was not in Mumbai. The accused must produce evidence such as travel records, witnesses, or photographs. Another example can be seen in civil disputes. Suppose a defendant admits signing a document but claims that his signature was obtained by fraud. Here, fraud is a particular fact asserted by the defendant, so the burden to prove fraud lies on the defendant. The core idea of section 103 is simple. Whoever wants the court to believe a specific fact must be prove that fact. This rule plays a very important role in practical litigations. Now we will understand how the burden of proof operates differently in civil cases and criminal cases. Although the basic principle remains same, that the person who asserts must prove, the standard of proof required in these two types of cases is very different. The, this difference exists because the consequences in criminal law are much more serious than in civil disputes. In civil cases, the standard of proof is called prepod- preponderance of probabilities. This means the court decides in favor of the party whose version appears more probable or more likely to be true. Absolute certainty is not required. For example, in a property dispute, if the judge feels there is a 51% probability that the plaintiff's claim is correct, the plaintiff may succeed. Civil law focus mainly on resolving private rights between individuals, so the level of proof is comparatively lower. In criminal cases, however, the burden on the prosecution is much heavier. The prosecution must prove the guilt of an accused beyond a reasonable doubt. This does not mean beyond all doubt, but it means there should be no reasonable uncertainty about the accused's guilt. If any reasonable doubt exists, the accused gets the benefit of that doubt and must be acquitted. This principle protects individuals from wrongful conviction and reflects the importance of personal liberty in criminal justice. However, there are certain situations where the law places a limited burden on the accused as well, especially when he claims special differences like exceptions under the penal code or facts within his special knowledge. Even then, the accused usually needs to prove only on the balance of probabilities, not beyond reasonable doubt. So the key point is that civil cases require probability, criminal cases require proof beyond reasonable doubt, and prosecution carries the primary evidence. In the final slide, we will quickly consolidate the important principles of the burden of proof that you must remember for day-to-day activities and practical understanding. The first and most fundamental rule is that the burden of proof lies on the person who asserts a fact, not on the person who denies it. The second important principle is the distinction between legal burden and evidential burden. Legal burden remains constant throughout the trial, while the evidential burden may shift from one party to another depending on the evidence produced. The third key concept comes from section 102, the test of no evidence. If neither party produces any evidence, the party who would lose the who would lose carries the burden of proof. If you found this video helpful, please like, share and subscribe. Thank you for watching.